All right, this is still Good Morning Nigeria, live on the network service of the NTA. And to begin our conversation on the task before the new CJN, let's quickly take a look at this background report put together by our correspondent, Ibrahim Dan Hamidu.
Justice Kudirat Kekere-Ekun's appointment marks a significant milestone in Nigeria's judicial history. As the second female Chief Justice, she brings over 3 decades of experience to the role. Born in London, United Kingdom, Justice Kekere-Ekun's parents are from Lagos State. Her father, Senator Hassan Adisa Babatunde Fasinro, was a senator and legal practitioner. Kekere-Ekun has been part of landmark judgments, including the Imo State governorship case. Her experience in the Supreme Court, Court of Appeal, and Lagos State High Court prepares her for the demands of the Chief Justice role. As Chief Justice, Kekere-Ekun faces key challenges: restoring public trust, implementing judicial reforms, and navigating political pressure while maintaining judicial independence. With her wealth of experience, Justice Kekere-Ekun is poised to lead the Nigerian judiciary toward a brighter future, upholding the Constitution and protecting citizens' rights. Now, the big question remains: will she succeed where others have struggled? Can she tame the political lions and bring sanity to the judiciary? Join us next as our expert panel dives into the trenches, exploring the triumphs and tribulations of Nigeria's new Chief Justice. The conversation is about to get real. Don't miss it.
All right. Thank you, Ibrahim Hamidu, for that background report. And to begin our conversation on the task before the new CJN, let me welcome here Ibrahim Modibo, political affairs analyst. A pleasure to welcome you to Good Morning Nigeria yet again.
Thank you.
All right, Yemre.
All right, and we also have with us right here in the studio James Igwe, SCN, a legal practitioner. Many thanks for joining us.
Thank you very kindly.
All right, looks like we're set for the conversation. We have other guests who will be joining us in the course of this discussion. I'm sure we'll introduce them when they join us.
All right, let me begin with James Igwe. You are a lawyer, law teacher, and so you are more familiar with the judiciary and the new CJN. What do we know about the new CJN, her track records, and well, we are discussing the task before her.
Right. Well, thank you very kindly once again. Let me first of all congratulate His Lordship, the Honorable Justice Montomori Olatokunbo Kekere-Ekun, on her Lordship's very historic appointment as Nigeria's second female Chief Justice and 23rd Chief Justice of Nigeria. I can assure you that His Lordship is coming to the seat of the CJN with a wealth of judicial experience and a very distinguished career. And just like you observed, I appeared before His Lordship in 1996 when she was appointed in July, I remember very well, of 1996. And I was a legal practitioner. I had just left the chambers of the legendary Chirotimi Williams in Lagos. And when we appeared before her, you know, you could see a judge that was very determined to deliver justice. And I remember very well, she was just barely about 2 or 3 months old in the bench. His Lordship had read the files very well and then said to me and my colleague, claimant, kindly look at paragraph XYZ of your claim. Defendant, kindly look at paragraph XYZ of your defense. And then it seems to me that both parties are in one accord in agreeing that the fundamental persons that will suffer if this trial goes on are the students of the school that was involved. Don't you think it was a matter that could be settled out of court? And right there and then, in fact, I had discussed with the counsel on the other side on the possibility of settlement before His Lordship came in. And right there and then, we agreed to meet and came back after a few days, and the matter was settled. And then when you appeared before His Lordship in those days in Lagos, you could feel the discipline. The court, her court, His Lordship's court was not a court where a council will come to seek for an adjournment. If you were appearing before her, you must be ready to go on with your matter. That was a kind of discipline that His Lordship brought to the bench. And no wonder, in 2004, she was elevated to the Court of Appeal. And in the Court of Appeal, she did very well. She sat in at least 5 judicial divisions of the Court of Appeal, and then presided in 2 divisions. I remember Makurdi and Akure. And then you could see the hard work evident in a plethora of cases. And then also, joining that with the challenge you have raised, you find that His Lordship is well equipped to handle whatever you call a challenge. Right from her involvement in the bench of Lagos State, she was actually in the committee that drafted the Code of Conduct for Judicial Officers in Lagos State. So in terms of Code of Conduct for Judicial Officers, right from the very beginning, she's well grounded on it. She was also in the committee that worked on a multi-house alternative dispute resolution for Lagos State, Africa's first multi-door courthouse, which is still there in Lagos State. And then also, she's also participated in training for judicial officers at that level. So you could see a Chief Justice of Nigeria that is well equipped to handle what you refer to as challenges, which we are going to discuss very shortly. And I'm very happy that is happening at this time. And I remember in that case, I turned to my colleague, George Oguntade, I said, His Lordship will go far. And my colleague said, yes. You could feel the discipline in her court in those days. So we are happy that is happening at this time. We thank Mr. President. We thank the NJC. We thank the judiciary. And it must be a time to ensure that we build on those solid foundations that have been laid. And mind you also, while Justice Ariwoola was the CJN, His Lordship was next in seniority. And so attended and was a member of the National Judicial Institute. She was a member of the Federal Judicial Service Commission. So she's well equipped. She knows what the challenges are. And in fact, she was a member of the committee that drafted the new Supreme Court Rules 2024 that is going to come into effect when the Supreme Court resumes by 30th of September this year. So you could see a well-equipped Chief Justice of Nigeria.
All right, well-equipped Chief Justice of Nigeria. Many thanks, James Igwe. I like the way you have spoken about the female Chief Justice, and I'd like to get to Dr. Modibo to just give us his overall impression about, who the new Chief Justice is, and then what are your thoughts about her performance during her tenure? What do you expect to see?
Well, as a development communication scholar, I have followed the trackings of Justice Kekere Ekun. This is a woman of substance, a woman that has paid her dues within the committee of the judiciary. This is a woman with discipline and character. This is a woman with charm, charisma, and also a woman that does not tolerate acts of indiscipline and corruption. Justice Kekere Ekun is a noted judicial expert. I'm so happy that when the Senior Advocate of Nigeria has been referring to her lordship as his lordship, it's just like the media. You know, the media we're not gender sensitive. Everybody is gentleman of the press, whether you're a woman or not, gentleman of the press. And here we see his lordship. It should have been her lordship. But that is not the issue of contention. So I'm educated. And journalists, the lawyers claim that they are learned. But let me tell you,
they are not the only learned people.
No, journalism is the only learned profession in the world. Because take us to the moon.
Louder, please, louder.
I said journalism is the only learned profession in the world.
Thank you very much.
Take the journalist to the moon, he'll cover. Take him under the sea, he'll cover. Take him to a legal profession, he'll cover. Take him to science and technology, he'll cover. Take him everywhere in the world, he'll cover. But can a lawyer do that?
Well, now,
Let's not derail the conversation. Some will also argue, a philosopher will tell you that a philosopher is for all times, all ages, all disciplines.
No, philosophy.
I'm the judge in this court, and what Dr. Modibo has said is binding on all of us. Journalists are the most learned.
So
and I have no right of appeal. So that's in breach of my rights.
When you get to your own court and take it up from there.
You can see that. So here we are with the newest Chief Justice of Nigeria, the 23rd in the hierarchy of Chief Justices in this country since maybe before independence or since independence. And I'm so happy that climbing through the ladder up to the peak or apex of the profession, where she was the deputy or the assistant to the former Chief Justice, and now she has climbed to the ladder. I'm so happy that this woman has been appointed as Chief Justice of Nigeria. And one fundamental issue that struck me about her was her interview, especially at the Senate, where she talked of instilling discipline and bringing character and distinction into the legal profession. You will agree with me that going by Bureau of Statistics index, recent index of Bureau of Statistics of Nigeria, the judiciary came tops in terms of corruption index, surpassing police, surpassing customs, surpassing everything. This woman should stamp her feet on the sands of time. She should leave an indelible mark in the judicial process by making fundamental reforms. These reforms should come in handy. I am sure that she's up to the task. Bear in mind that she stated clearly that she should not tolerate indiscipline. She should not tolerate corruption. And if you look at the myriad of problems, well, especially if you look at by way of general analysis, you'll agree with me, the presenter, that this woman needs to come forcefully, diplomatically, judicially, and whatever to ensure that the Nigerian judicial system has been overhauled. There is a need for her as an agenda to make sure that where there are pitfalls, she will be able to block them. In trying to break the barriers to define the narrative, I will employ, and she also knows that she is under no illusion as to the myriad of problems confronting the Nigerian judicial system and the Nigerian society in general. Because the judiciary cannot be isolated from the public. The public perception of the judiciary today, it is abysmally low, and it is unfortunate. Bearing in mind that you see court judgments from the same courts of the same level, this judgment here, dancing to the whims and pandering to the whims and caprices of the politicians. It's unfortunate. What we know of judiciary before is these are people of character and distinction. Wherever you see a judicial officer, you must respect him. They don't go to parties where they drink anyhow and dance anyhow and they shout. They are always guided by the ethics and etiquette of the profession. You see a complete gentleman. Especially if you're a judge, you're supposed to just not be heard loudly anywhere. But what are we seeing these days? You just see some of the judges going to parties and then doing O1B, drinking beer. And you see, so this discipline must be enthroned. This woman should come in and make sure that, look, as she promised, I want to believe that there are a lot of issues in contention that the present Chief Justice must confront, especially reforming the electronic device system, where now judges write in shorthand. It takes them time, and again, to be writing their judgments and what have you, taking evidences and what have you. And also, if you look at the issue, if you look at the issues of even registrars, I think it's time now we have lawyers employed as registrars in courts of jurisdiction. Therefore, if we see all these school leavers by way of professional calling, if we employ lawyers as registrars of the courts, they will be able to look at the issues of the courts dispassionately and also be able to fill in the gaps where there are gaps. So, in going back to basics, I think first and foremost is to make sure that the judiciary is people by people of character and learning. We should have people that be tested and trusted, not bringing people from everywhere, anywhere, because they are lawyers, and they have not even gone to courts. They have not even been able to, either as solicitors, advocates, or at the bar. You raise them to the apex list of high court judges. It's unfortunate. It's travesty of justice. And we also see a situation where people are now employing their own sons and daughters as judges of high courts and what have you. When has it become a family affair? The judiciary should be a kind of inheritance. It's never done. Judiciary are people by people of character, why we see judgments, sound judgments. I could remember people like Justice Nikitobi and what have you. When we were in Maiduguri, in the early 80s as university student, I knew when he was our dean. This person, look, if you look at some of the judgments, look at the English, look at the texture in terms of articulation of ideas, the sound judgments. But what we have now, I don't know.
I'm wondering if I can
we think, of course, you will call me. Let me thank Dr. Ibrahim Modibo, first and foremost, development communication scholar and public affairs analyst. We thank you for the points you have raised. He has raised quite a number of issues, but these are just some.
Right. I would like to
These are
address,
just some.
I would like to address some of the points that, with respect to Alhaji Modibo, with respect to him, I'd like to address some of the points that he has raised. And let me tell you, the judiciary is perhaps the most hard-working arm of the government in Nigeria. These judges work so hard. I'll give you an illustration. In the 2023-2024 legal year, started in September 2023 and ended in July 2024, 1,124 cases were filed in Nigeria's Supreme Court. At that time, they were only this was before the appointment of the new justices, only 15 honorable justices. 1,124 cases were filed, and they delivered 274 judgments. I'm coming.
This is noted.
No, hold on. I just want to respond to his point because I'm here.
Yeah, because you said you were going to respond
yes,
to him.
I want to respond to his point.
He didn't say they don't work hard.
I'm laying a foundation. I'm laying a foundation. Please just give me a minute. I'm laying a foundation. They delivered 247 judgments. They don't even have time to themselves. U.S. Supreme Court received only 62 and delivered opinions in 60. U.S. Supreme Court, in that same term, they call their own term, we call our own legal year. Between 2022 to 2007 and 2022, only 1,188 cases were filed in the U.S. Supreme Court. I'm laying an example. I'm laying a foundation. So the honorable judges and justices are not able to respond to all criticisms by the nature of their training. They don't even have the time. And so a lot of the perceptions you find in the public domain, in the social media, are not true. And I'm speaking as an insider. Okay? Now, when you say corruption, the judiciary has a mechanism of dealing with petitions on corruption. And they are recorded. The files are there. The records are there. Nothing is hidden. Okay? And then you find out that when you compare that with the other arms of government, it's abysmally low. I don't know where they're getting these statistics because the judges will not even respond. If you ask them to respond, they don't even have the time. A judge goes to court, sits at 9 o'clock, and then gets up about 2-3 p.m., goes home and starts reading his files for the next day. The socialization you're talking about, I haven't seen that. We haven't seen that.
Anyways,
Let's take
anyways.
Let's take this in beats.
Yes.
You know what? Let's take this in beats so that we don't muddle things up.
Right.
He made clear allegations.
Yes.
He said, of course, are you going to deny that you have judgments, counter judgments here and there from the same levels of courts? Is that not what we see?
Judges are human beings.
You said you don't know. You said you didn't know.
Hold on. There are precedents that guide cases.
But we've seen a case
Precedents
where
are there that guides cases. And that's why you have the Supreme Court. You see, the Supreme Court, people don't always know. Supreme Court is the apex court and is a policy court. The court, and then the Constitution is there. The electoral acts are there. And then you know politicians, every politician wants to make sure to win his case. We must be able to see, and also we must be able to accept defeats. If you win a case, glory be to God. If you lose a case, accept defeat and get on. Politicians don't want to accept defeat.
What about the kind of statements credited to a former CJN when he had the G7, G5 debacle in the PDP? That's also part of the things he's talking about. These are in the public domain, so you can't say they don't exist.
Hold on. I'm not saying that there are no isolated cases of complaints here and there. But I'm saying that the judiciary itself has a way of dealing with those challenges better than any arm of government. And these judges are overworked. So it is not good to just throw allegations. I'm coming to throw allegations on. I'm not a judge, but at least I conduct extensive research on the cases you're talking about. Now, if you lose a case as a lawyer, your answer should be to criticize that case in another case or write an criticism in a law journal. Not to go to the press, not to because there are cases in court. And remember that some of these emotional statements affect life cases in court. If you see the way these honorable judges suffer themselves to deliver, to conduct justice delivery, I've just cited an example of the current CJN when she started. You could feel the discipline. Now, I am not saying that there are no isolated cases of misconduct here and there, or maybe if some of them. But the judiciary itself has a process of dealing with it more than any arm of government. And remember that these are public officers who, by the nature of their work, cannot speak to the press. So they cannot conduct public enlightenment, unlike the Senate, unlike the executive. Do you appreciate where I'm coming from? It's just a perception. So the question should actually be, how would the CJN coordinate in the process of coordination or administration of justice? And it's not her responsibility alone. It's also the responsibility of all heads of court, the Court of Appeal, the Federal High Court, the State's Court, to ensure that at least there's a public enlightenment department in their courts that can, after all, we have Freedom of Information Act, that can furnish the appropriate information to the public. And in that way, if that is done, I can assure you that most of the misconceptions that you have about the judiciary will be taken care of.
If you say misconceptions, Dr. Modibo tried to highlight some of the issues in the past that has made judiciary, a bit reduced in the eyes of the average Nigerian. Let's just look at the Emirship Torso in Kano, for example, and all that played out. Would you say that the judiciary undo that properly?
The case went to Supreme Court. The Supreme Court decided everywhere is calm. You see, you have the Constitution created a judiciary.
Has it been decided?
I'm coming.
It has not been decided.
No, okay, you're talking about the Emirship Torso. No, okay, I thought you were talking about the governorship Torso.
Emirship Torso.
The case is in court. People should keep quiet and let the case and let judges do their work. Are you now the judge? And then when I read what people write on the media, they're already telling the judge what his judgment would be. The facts, listen, this is how a case decided. You win or lose a case by your pleadings. You will state in your statement of defense or claim, this is what the issue is. The defendant will state his own. The case will go to court. The lawyers will address the court on it. Based on the facts before the judge. A judge is not supposed to take facts of a case from the television or from interviews. A judge looks at the facts before him. You'll be amazed that the public is saying a different thing. The lawyer has presented a different thing before the judge. It is the facts before the judge. So let the court do their work.
Okay, Leonard
Leave
Silk.
them to do their work.
Leonard Silk, what in your opinion is the task before the new CJN?
In my opinion, all the challenges with what you call as task, you will see that the judiciary is ahead of the game. They have a national judicial policy to 2013. And that national judicial policy examined all the challenges and plausible challenges. Okay? First of all, the first one, which I can narrow down to his question, is judicial independence and accountability. That is policy number 1 in the National Judicial Policy of 2013. That was when it was reviewed. It talks about the judge, when you are dealing with cases before you, to ensure that you are independent and then you ensure that you're not in any way influenced. And then the second policy number 2 is to ensure accountability of the judge. That is when you're deciding a case. But you see, the challenge before the CJN will be ensuring a more effective case management system. Like I told you, the Supreme Court, for example, is overworked. It is the most overburdened court in the whole world. I have just told you that in 2023 to 2024 legal year that ended in July 2024, 1,124 cases were filed in Nigeria Supreme Court. You have only, at that time, 15 honorable justices to deal with 1,124, the most overburdened Supreme Court in the whole world. Supreme Court of the United States, that was founded more than 200 years ago in the 17th century, had only 62 cases referred to them. They dismissed 2 and gave opinion in only 60. This is so one of the challenges I see is, how do you develop a proper case management matrix, and also to follow up the register of cases, to track them down, because you have so many cases in Supreme Court. You have cases that have been there for 4 years, 5 years, 6 years, 7 years. Again, also, it's not even it will be a challenge that you need a proper coordination between the Nigerian Bar Association, the lawyers themselves, and the courts to solve, because most of those cases arise because the politicians, okay, you file frivolous appeals. They file interlocutory appeals, and interlocutory appeals is an appeal that will arise from a major case. A judge rules on a minor case that you should let the entire trial to take place. You say no. The politician will say, no, no, no. Go to Court of Appeal. And then you go to Court of Appeal, you stay there for 4 years. He said, no, 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 no. Go to Supreme Court. Remember that the main case is still at the trial court. And by the time you exhaust these layers of appeals, 8 years. In fact, even His Lordship, the Honorable the CJN now, in the case of Braithwaite and Dahatu, spoke against it. He said, look, the case before us, we have been ready to go on with this matter. But looking at it, it's now 12 years that the interlocutory decision was given in the High Court, and a lawyer appealed on it. So the problem is also the politicians.
But isn't that a problem in itself? That's
what I'm saying.
You don't exhaust issues. So why should you be allowed to go to?
Hold on. So the challenge will be. So can I please? Let me finish. Hold on. Let me finish. Yeah, so the challenge will be, now that there is a constitutional amendment. Now there's a constitutional amendment. It's a responsibility amongst all the arms of government to ensure a constitutional amendment where interlocutory appeals will stop at the Court of Appeal.
All right, many thanks, James Igwe, SAN, for the comments that you have made. Of course, you did make a point. You said most of the time what is in the media space is not what is before the judge.
Yes.
And of course, when you said that, what came to my mind was the Supreme Court judgment in 2020, for instance, that sacked Emeka Ihedioha from office as governor of Imo State, where the number of votes cast actually outnumbered the total accredited voters, and is still, causing confusion in certain circles. Dr. Modibo, I want you to respond to some of the comments that the Leonard SAN has made, and then talk about what the CJN has to do differently, because we've had so many court cases. He's talked about putting the blame on the politicians, but of course, most cases that are political, the judgments always come out and Nigerians are wondering, what they didn't see. So please, respond to some of the comments.
You see, with due respect to Elana Silk, what I was emphasizing on is the issue of giving parallel judgments at coordinated courts. If you look at the issue of Kano that we talked about, on the issue of the emirship tussle, the State High Court is giving different judgment, the Federal High Court still in Kano giving different judgment. And they are all coordinated courts. So how do we look at this issue? So one of the fundamental reasons that should come to the current Chief Justice is to make reforms, where if you go to State High Court, if you are not satisfied, you go to Appeal Court, then maybe to Supreme Court. And on the issue of court system, there is a need for urgent reform. This, her lordship or his lordship, stepping in, should be able to see to the possibility of creating special courts for politics, where we have cases maybe decided by retired justices in conjunction maybe with justices. Why can't we employ more Supreme Court justices, or why can't we bring in more Supreme Court justices? There are so many people that are qualified. Establish special. No, excuse
You
me.
would respond,
moment, sir.
James
Wait,
Igwe, you
wait.
respond when he's done.
The silk.
you.
No.
I want to help
You are not
you.
helping me. Just wait. So, you see, if you look at all this, and is the silk saying that the Bureau of National Statistics are liars? They are not liars. It's based on empirical evidences that they'll be able to get these facts, why they stated clearly in their recent report. Let him go and read it. That the judiciary top ranks in terms of corruption index in Nigeria, followed surpassing police, surpassing customs. So you can see the trajectory and the tragedy that is encapsulated in the judicial system, of which is inherited. Therefore, to me, as a follower, as a scholar, and also somebody that has, well, as a development communication expert, I have a PhD in development communication, and therefore, I have been able to follow the trackings of the judiciary and other national events. Therefore, as far as I'm concerned, the issue that is confronting this woman today, there are myriad of problems. There is a need for her to make sure that the NJC takes seriously the issue of looking at judges or lawyers that are faulted and disciplining them immediately. Look at, for instance, most of the lawyers, as he's talking, is sub judice. For you to come to the media and start talking on process of courts that are presently pending, and that is what most of them do. They go to the area, NTA, the channels, and all. They discuss some of this, and it's sub judice. The current Chief Justice should be able to look dispassionately into this and stop it. Two, the issue of lawyers, the issue of judges. Now, thank God, they've been adequately remunerated. They are the only ones in Nigeria today whose salaries have increased by 300%. When other civil servants are getting less than 50%, they are having 300%. That is a good motivation. It's enough this thing to make them sit up and look dispassionately into the issues of the judiciary. Because the judiciary is the last of the common man. Believe me, if the judiciary fails, as it is failing now, abysmally low, in the eyes of the reasonable thinking public, it is going to be a recipe for chaos and disaster. God forbid. Therefore, Justice Kekereekun, it's time for her to step in to the fray, to make sure that she brings in fundamental reforms that could make sure that Nigeria's judiciary gets back to the apex of its responsibility and also responsibility. To me, I cannot see the details in some of these cases, coming up political cases, why somebody that came number 3 will automatically be flunked to number 1 when the number 2 is there. So, what kind of judgments are these? Sometimes when I sit, I weep. Because some of these judgments that I see, it is just like abracadabra. The more you see, or the more you look, the less you see. Because I cannot fathom. Madam Presenter, I was a court clerk. I was a court clerk in the court system of this country in 1978, when my salary then was 78 naira. I was a court clerk when I finished my secondary school. I started then before going to the university in the 80s. So I have known judges. If you see a judge that time, believe me, a judge was just like a mini god, court and uncourt, because of character, personality, distinction, and also sound judgment based on fundamentals of the law, not judgments that are tied to the aprons or strings of politics.
All right.
We should correct this.
all right.
We should not be subservient to.
Of course,
some
so
of these,
that's what we're hoping that the CJN would correct.
Right,
No, now,
yeah.
now, just I know you want to respond to him. You know, the issue of interference. A lot of people have said that in the judiciary at the moment, you know, even about the cliche about judiciary being the last hope of the common man. Some say not anymore because it's about who can buy justice now. And talking about buying justice, I mean, I'm sure you saw that in the news. Where a ranking senator came out to talk about how, you know, somebody who, you know, is related to him, you know, influenced judgments and all of that. And then you get to see all of that happening. How can the CJN, you know, handle, you know, the issue of interference in terms of politicians, or if you like, political office holders interfering with cases in court and how it goes?
Okay, now let me answer your question by asking you a question.
That will not be an answer.
You see, people make allegations. You need to have somebody who says, I gave money to a judge. If somebody makes an allegation, you should put up a petition. And like I told you, judiciary has a mechanism of working on it. And there's also impression that I want to correct. Now, if you look at the national judicial policy, it spells out the fact that the judiciary should have a cordial relationship with the executive arm of government. Now, you don't know that the federal judicial system, as created by Section 153 of the Constitution, is an executive body. The Federal Judicial Service Commission is an executive body headed by the Chief Justice of Nigeria. The National Judicial Council you're talking about, created by the Constitution, Section 153 of the Constitution, 1999 Constitution as amended, is an executive body, but headed by the Chief Justice of Nigeria. So you need to draw two very distinctions. When the judges are dealing with cases before them, that is where you talk about judicial independence and non-interference. When the Chief Justice of Nigeria, including the President of the Court of Appeal and heads of courts, are dealing with issues that concern the development of the judiciary and indeed the development of Nigeria, because if you look at the preamble to Nigerian Constitution, it talks about giving to ourselves a constitution that guarantees justice. Then there must be a relationship with the other arms of government in order to ensure that the welfare of the judicial officers, to ensure that Nigerian development is upheld. Now, there are other, I was expecting us to get to other key challenges like technology and so on and so forth. But we were talking about dealing with issues before the court. The Kanu case you're talking about is sub judice. Leave the court to do its work. When the high courts finish, they'll go to court of appeal. There's only one court of appeal. An issue in a case, an aspect of a case might revolve on jurisdiction of the federal high court. An aspect might revolve on the jurisdiction of the state court. So whichever court at that level that has jurisdiction, which is what he's referring to be evident, if you go to court of appeal will say, no, it is either the federal high court or the court of or the state court that has jurisdiction. Stop discussing life issues before the court, because the facts are before the court. Let the courts do their work. Okay? Yes, judges are human beings. There are a lot of the occasions that there are disparities in judgment, but then that's why you have judicial precedent. So the challenge before the Supreme Court is to emphasize and ensure that decisions follow the ones that were already been dealt with before. That is what is called the doctrine of judicial precedent. And if that is done and done very well, a court of appeal has no reason to depart from a judgment of the Supreme Court. The Supreme Court has no reason to depart from its judgment except under very special circumstances. But it's a policy court, okay? So these are some of the things on the ground. So it is not good to just lay allegations. Yes, there are a few cases, like the case you mentioned on Imo case. People are entitled to speak about it. But if you have any reason to, on that matter, this decision has been given. Write about it and let us read about it. For information, I was in that case. I may not be happy, but it's not about me. It's about the system. It's about Nigeria. It's about having a nation where there is peace. In fact, one of the writings of His Lordship, I've read a lot of the new CJN's writings. She's well learned and she's written extensively. Is law as a tool of social justice. A presentation she made in 2010 in Ibadan. If you read that, you see a CJN that is conscious about these things. Judges are human beings. They can make mistakes.
All right.
Mistakes may have been making in a few cases. There may be other reasons that are apparent on the record that we don't know about. And as lawyers, we accept whatever decision. We can grumble about it.
Of
we
course,
can criticize
you
it.
have to
Are some mistakes pardonable? For example, like the certified true copy, having a different version.
I don't know
out there.
about that. I didn't. What I'm saying is that I cannot speak about that because I did not apply for a certified true. I can only speak about what I have just told you about what I know about the CJN, and I'm speaking from my personal knowledge. Now, most of the thing, what I'm saying is that if you told me that NTA commissioned its legal department to obtain a certified true judgment of that case, and this is what you find, I will say yes. But we are just reading different versions of same foundational story from several sources. Leave the court to do their
All
work.
right. Thank you, Leonard Silk. I was going to ask, when at a point I had to ask you,
Yes.
what do you consider the task before this new CJN? And now you've alluded to technology at some point. I'm
Yes.
going to ask, do you think that the Supreme Court, as currently constituted, has all the complements, the number of judges that it should have? And what can technology do in this circumstance? How much can technology do?
Right, excellent. Now, the Constitution limits the number of honorable justices of the Supreme Court to 21. Right now, I think
we
they
have
have
21?
21. 2-1.
Do we have 21?
We don't have 22. I think we have 20 now. Okay? But then we can review the Constitution to expand the number of honorable justices, having regard to the fact that we're a country of over 200 million people. Imagine the kind of cases that could go to court, like the former Honorable Chief Justice of Nigeria mentioned, a case involving 12 goats. Somebody alleged that somebody else took his 12 goats and he went from a customary court to high court to court of appeal to Supreme Court. By then 20 years had elapsed. 12 goats. So it is a responsibility not just for the CJN.
So that's part of the reforms that we should see.
Exactly. Constitutional reforms at this time. Now, technology is important.
Okay.
Coincidentally, this CJN is equipped to handle it. Right back in 1996, she was a member of the committee that reformed the Lagos judiciary regarding their ICT, regarding the code of conduct, regarding the ADR. At the Court of Appeal, she headed the ICT committee of the Court of Appeal while she was there. Now, during the tenure of my Lord Honorable Justice Kayode Ariwola, she also headed the rules committee that came up with the new rules of the Supreme Court 2024. And that rules recognized the need for enhanced technology. Now, we're still trying to deal with elementary technology. You now have artificial intelligence that even courts across the world are beginning to look at how to enhance what they are doing. It will amaze you. Go to Supreme Court. They still take writings in long hands. Go to the filing department. You see a whole lot of files flung and scattered. They need more funding. And you see, we just keep laying blames on the courts. Section 1629 of the Constitution talks about public revenue in Nigeria. It says that the funds to the credit of the judiciary shall be paid over to the National Judicial Council for disbursement to the heads of courts. But you don't find this done in the states. The state governors receive the funds. They want the chief judge to come hand begging. Welfare of the honorable judges you're talking about, you just heard about the bill that was signed only yesterday that has yet to be implemented. Go and see how these judges that work so hard, serve your nation for 30, 35 years, you don't have a home to go with. Except for Ebonyi State that recently recognized the fact that retired judges need to have decent homes. In all the states, you see judges dying, they can't afford medical
including Rivers
attention.
State?
Ebonyi State,
including
yes.
Rivers? Are you saying judges in Rivers State are also...
No, I'm talking about, I mentioned Ebonyi, I didn't mention Rivers.
Yeah, but you said across the 36 states, so I'm just mentioning...
Yeah, I'm saying across the 36 states, most of the governors would not credit this fund to the head of the judiciary. Why would you not? If you go to the court, visit a court in the Kanu he talked about. Visit a court in Abia you talked about. You see dilapidated structures. This must be the time for the Honorable Chief Justice of Nigeria, using judicial policy number 3 that talks about cordial relationship with other arms of government, to draw attention to the executive. Ensure, let Mr. President, I'm just happy about what happened with the local government funding case, where the Supreme Court decided that the funds to go straight to local government council. That is the same thing you are having with the judiciary. The state governors hold back the funds of the judiciary. You go there, you find out that judges would not have funds for transportation to deal with essential things. Even the court clerks you're talking about, the essential things, the papers, the files, they're not there.
Of course, that's one area.
So that's one area.
We're expecting the CJN to look at, and that would take care of state capture of the judiciary, which is a problem,
right.
Across different states. But let's quickly hear from Dr. Modibo also. We'll come back to you, Dr. Modibo. Listening to the learned essay and talk and all of that, and trying to make us feel that maybe we're not doing enough, or maybe Nigeria is not doing enough to judicial officers. Some would say that judicial officers get all that they should get, and maybe because corruption, like you have mentioned, has eaten deep into the system, is why we see what we see. But let's look specifically at the CJN now. Some say that the powers which she controls are too much. Do you agree with that thought, or you think that the way it is at the moment, looking at all that she controls, is in the right place?
Thank you very much for that question. But before I delve into that, let me place a caveat. I came from the home of the judiciary, or judicial officer. My father was an area court judge in those days. Therefore, I will never, for any reason, disparage the judiciary. All I'm conversing for is for good judiciary, a judicial system will respect, that will earn respect of Nigerians, so as to move itself away from the public perception of being abysmal in law. This is a caveat. Now, how do we defend? There are fundamental cases that you've even cited. I'm so happy. Issues of 2 cases of fundamental importance. One, the issue of former Senate President Ahmed Lawan and the current Senate President Akpabio. 2 of them went and contested for the presidency and came back. After they lost, do you buy 2 forms simultaneously at a time to contest for 2 different elections? When you lose there, you hang on to the other one. So if you look at this, these are some of the fundamental issues that bring ridicule to the judiciary. For a judicial system to allow, to say that, look, this person has won in that election, and you just went and lost election in the presidency, you came and captured.
Dr. Modibo, but I think it's established. It's established. We're looking at the task before the new CJN.
Yes.
It's established that there is indiscipline. It's established that there is work to be done in that area. I'm not sure that we need to start, recalling cases.
It's very important.
It's established that there's something to deal with in that area.
You see, in terms, I always recall, with nostalgia, the philosophical thinking of Joseph Santayana. He precisely stated that if experience is not retained, infancy is perpetual. Those that forget the past are doomed to repeat it. The history is very fundamental. These are some of the pitfalls that this woman should look into, where the Supreme Court will come and make judgments based on political considerations, because I cannot see in the whole of this world where you have 2 nominations, after you lose that one, you come and hang on to it. That is one. Then secondly,
all of this can be captured under the need to look at how judgments
and even look at the issue of rivers. The issue of rivers at the moment,
can be captured.
You see this Federal High Court giving this judgment, State High Court giving. So now, to the point, Justice Kekereekun, that has just been nominated, I'm sure she has
confirmed.
I'm sure she's equal to the task. And my appeal is for her to put into consideration, as your question goes. First and foremost, let her overhaul the judicial system. It's very fundamental. Look at the issue of employment opportunities. Look at the issue of technology. Bring technology to these people. I'm happy that the Lawyer Cell has given us tabulation computation of some of the cases as compared to the US. But the US framework is different from that of Nigeria, because if you look at the issue of judgments in the US, they have, there are issue of even dispute resolution mechanism. So why can't we form it here? If you have political cases that you think is too much to add to the burden of the current Supreme Court, why can't you form a dispute resolution mechanism that will encompass one, retired justices of character and decision? Form them. Make sure that they go into these cases and make it since they've been learned and they've been into practice for a very long time. Let it be a final, let them be the final arbiter. Rather than endorsing this, and look at the issue of even some of these governors. There are governors that since 1999 that have looted Nigeria's economy. They've drained Nigeria dry. They've stolen Nigeria's money. Up to today, they have not been convicted. None of them is in prison. It's only when you still goat or chicken that they will take you to prison.
It is the case that comes before the court.
That is what we're saying.
And some of these governors, to be honest, have been in jail. Some of them have been in jail.
How many? If I may ask, only 2. And all the 2 have just been given pardon.
That depends on diligent prosecution.
What we're saying is here, my brother. The issue of the judiciary. No, excuse me, Silk. Wait. You'll be giving your time so much. So allow me to tell you what I feel. Under the current circumstances, you should look dispassionately at dispensation of justice based on justice. The cases that are delayed since 1999 up to the present does not give justice. If you have stolen, that is why today people steal with impunity. They go into office with the mindset of looting. They steal, and nothing will happen because they believe that if they steal, they have their way out. So we should look dispassionate justice. Kekere should see to the dispensation of most of these people that have been accused of pilfering our money. Look at today, because of impunity, the governor of Kogi State, courts have been inviting him to come. Federal High Court to Andisi. About 6 times now he refused to come. Is that no impunity? If the judicial
But
system...
the people of Kogi said money is not missing.
That's not the issue.
No, excuse me. The EFCC,
You will.
Anyways.
the EFCC is, it has a prosecutor. It has done investigation. Whether the Kogi people, most of these people are lapdogs of the current governor. Therefore, EFCC is an independent body that has been vested with the responsibility of searching and then giving to their lawyers to prosecute. They have a case. Let him come to the court. If not, why is he afraid of coming to the court? And today, the court seems to be helpless. It seems to be helpless because they refuse to come. So, I am not laying the blame on the doorsteps of
the courts, because the EFCC hasn't done enough.
No, EFCC has done enough. Don't blame it. It has a case at hand. I know.
Has it brought the accused?
How can you bring the accused when the accused has been dodging? If court gives you, summons you, it was just like God then summoning you. But now, court will summon you and with impunity.
In other words, you are talking about the perception of the judiciary.
Not the perception
of Nigeria.
My brother, don't be citing the judiciary. Not the perception. The fact on the ground. The fact on the ground is that this man has refused. It's impunity.
Dr. Modibo, I think we should just take a break at this point. When we come back, we'll talk some more on this topic. Stay with us. All right, welcome back. It's still Good Morning Nigeria, live on the network service of the NTA. And our topic for today is the task ahead for the new CJN. We have 2 guests, and if you've been following, it's been a very heated one. And of course, we still have Dr. Modibo with us and James Igwe SEN. I'd like to get to James Igwe SEN now. You wanted to respond before we went on that break to some comments made by Dr. Modibo. I'd like you to respond to that. And also let us know if there is immunity for erring judicial officers and what the CJN can do in that regard. Because we're talking about perception in the eyes of the public. What has come to question in some quarters is the fact that even when a judicial officer is found, to have, done something not appropriate, we only hear of suspension and nothing more. So is there something, or you think that, what would you like to see the CJN do, to erring judicial officers, or what can the law, begin to recommend, just so that the average Nigerian, knows that, okay, this judgment also gets to those who judge?
Yeah, thank you very kindly. And just like you said, let me respond to the very last salvo he fired to the judiciary. When a case is before a court and a court makes an order, it is not the responsibility of the court to go and arrest a person. The responsibility immediately becomes that of the executive. The executive controls the police. The executive controls the EFCC that brought him. And also, it is how whatever facts the prosecutor brings to the court that the honorable judges look at. So that is not a kind of blame. And that is what I'm talking about, the wrong public perception. But because, and to answer your question, all our courts needs to ensure that their public sector department, establish a viable public awareness department where you can quickly respond to some of these issues. Because the judges are very busy. They don't care what anybody is saying. They're just caring about the facts before them. It must be a time for also the Honorable Court, because it's part of our judicial policy. It's a key judicial policy for every court to establish a public awareness department. So I am urging His Lordship, the Honorable the Chief Justice of Nigeria, who is well equipped with all the trainings right from when he was a judge at the Lagos High Court, where I personally appeared before her and saw a very disciplined judge, a very brilliant, very erudite, deep in thinking, to ensure, to bring it to the meeting, because they have an administration of justice committee, and to make it compulsory, and then also to ensure that, like I mentioned, the funds allocated to them from the Consolidated Revenue Fund, you must make sure it gets to them, because if they don't have a fund, for example, they can't run what I'm suggesting. So they need to establish it. And they also find a way to, most of the times, the law reports you see of these cases, he mentioned 2 isolated cases, but I just told you that Supreme Court alone delivered 247 judgments in 1 year. And here we are, isolating only 2 political cases to use it to condemn the entire judiciary. That is unfair to them. I'm not saying that I have not lost a case. I lose a case, I file an appeal. I lose at the Supreme Court, I say I have done my very best. Let it be at every point in time that a lawyer in his research will beat his chest and say, I have done my very best and I lost. You'll be happy that you lost. And I have lost a case in Supreme Court where the client came to me to thank me and said, I saw how you worked. I read your brief. I gave your briefs around to people to read, and they said, wow, this is one of the best briefs I've ever written. But unfortunately, perhaps, the court saw a point that didn't favor me. And so I give glory to God. That's how it should be. And then we lawyers must also learn to avoid filing frivolous appeals and also chasing shadows where we shouldn't. There are several challenges before His Lordship. Like I said, the first judicial policy number 1 is that of independence and impartiality. Now,
would you say the judiciary is independent as it is today?
When it comes to dealing with their cases, judiciary is independent. They are aware. The legendary Lord Denning, in his treatise on the road to justice, said, and I quote from my head, when you set out on this road to justice, you will remember there are 2 great objects to be attained. One is to see that the laws are just, and I'll come to that because we must ensure that our laws are just. The other is to show that the laws are justly administered. Of the 2, the most important is that they are justly administered. In the administration of justice in the cases, there are isolated cases. And coming to your question, the National Judicial Council has a disciplinary measure committee process of dealing with them, but they are not published. It is not just suspension. Judges have been dismissed. The records are there. Judges of appellate courts, Court of Appeal, have been dismissed. In this, and nobody is talking about it. They don't talk about it because most of the times they want to make sure they keep the confidence of a case. And then there's also a policy that when you write a petition, don't publish it in the papers. Don't go to the media. Let them do their work based on the facts of the case. And then when they deal with those cases, they don't even bother going to publish it. So I am saying that based on her, because the new CJN headed what they call the Public Awareness Committee in Lagos State, where people came and spoke about what they wanted to see in the judiciary in Lagos State. So she had had an interaction with lawyers and with ordinary citizens. Let his lordship bring that wealth of experience, judicial experience, to bear on this tax. And I'm certainly sure she will. And then there's another issue. Luckily, the new Supreme Court rules has helped to reform the ADR system in the Supreme Court. A whole lot of the cases, they have so many cases that are locked up there. Perhaps the new CJN should set up a small committee comprising a few honorable justices and a few staff of the Supreme Court to look at these cases and advise litigants on the ones that should go to the ADR. In that case, you reduce the docket. I have cases that have been there for 7 years, 8 years.
So what can the CJN do in that regard, in trying to hasten judgments?
Effective case management system. She's already trained to deal with that. Effective case management system where you can look at the dockets, isolate those that should go to ADR, okay? And now that you have about 20 honorable justices, quickly ensure that the panels deal with them, and then have the numerous conferences they have, make it more regular, so that it is in those conferences that judges are able to unite their views. In that way, you don't have differing judgments that he's referring to. So the new CJN is armed and equipped to do that. So his lordship should get to that work by the grace of God, and God will give her the strength as quickly as possible to deal with it. And then there's another thing which I keep emphasizing on. When we talk about judicial independence, we should look at it in the context of cases before them, not in the context of administration of justice, because the judiciary is not an Ireland on its own. The Constitution of Nigeria created 3 arms of government, sections 4, 5, and 6, created the legislature, the executive, and then the judiciary under section 6. So the CJN would have to fashion a way of ensuring that there is a harmonious working relationship with the arms of the government without compromising the doctrine of separation of powers you will find embedded in the 1999 Constitution. So it's a thing that requires a lot of judicial diplomacy, a lot of engineering, a lot of architectural designing and redesigning, and also ensuring that the other heads of courts are carried along. But the executive has even more work to do, because a lot of the governors, they deprive the judiciary of the requisite fundings that they need to develop the judiciary. So that should stop. And then we also have the problem of outdated laws. It is not the function of the judge to reform the law. And as His Lordship, the Honorable Justice Oliver Wendell Holmes say, whatever the judges say and nothing more pretentious, that's what I mean by the law. So the judges only pronounce on what is the law before them. Okay? Now, when they come to talk about what ought to be the law, you say, oh, they have delivered a technical judgment. Just like in the local government case, they said, no, it must be the intention of our forefathers, those who sat in the Constitutional Review Committee of 1978, headed by my former boss, the legendary Chirutumi Williams, to that it must be that all the funds that are due to the local government councils must go to them directly. We don't care what section 1625 is saying. So governors, this money must be sent to them directly. So if that is done, it's just a way of ensuring that the CJN is able to ensure that we get across to the requisite, to the appropriate persons in the executive to do that and implement that and ensure it's done. And then there's one more challenge, which is administration of justice. Now, access to justice is very, very low, because you find out that we have very few courts. I'm talking about, so CJN must have to ensure that the chief judges of states, who are members of the National Judicial Council, do what they need to do. Okay, but the executive also has far more responsibility in that, because we need to increase their budget. The national judicial policy is such that the honorable judges are barred from lobbying the National Assembly. They don't expect the judiciary to come to them lobbying for increase. It must be something that the legal committee of the National Assembly looks at, liaises with the chief registrar of the courts, and takes what ought to be the appropriate budget for the court system. You don't expect them to come to you because by the national judicial policy, they are barred from going to lobby. And so when the funds are abysmally low, the hands are tied and they can hardly do anything.
But I think that chairmen of the judiciary committees, with due respect, in the Senate, in the House of Representatives, I do know that they try to do their best. Of course, what comes out of it is a matter of how much funds are available. But thank you very much, Leonard Silk. Let me get to Dr. Modibo. Now, in your opinion, how much of an issue would you say appointments in the judiciary has become, and then training of officers?
Thank you for that question. Now, I wish Justice Kekere well. And by the grace of God, by the time maybe she will finish her tenure, she would record some major landmarks, which will have a pride of place in the annals of this country. Fundamentally, what I see is this a woman that came in to meet a country that has been plagued by challenges of corruption, spiritually indiscipline, gross impunity, security challenges, and monumental poverty in the midst of plenty. How does she look at the issues of contention such as this in trying to modify the judiciary? Fundamentally, one, let me make a suggestion. She should make sure that there is judicial independence in terms of, as the Lana Sika rightly stated, in terms of funding, both the federal and the states. Because the states, most of the high courts of the state are pandering to the whims and caprices of the governors because they're tied to the government of the state because of funding. Let there be independence in terms of funding for the judiciary.
I'm just wondering. Now, he says, I'm sorry, just so that we don't miss the point. He said the judges are barred from going to lobby. Now, that's taken. But just like in the case of the local government, funding, can somebody not go to court, for instance, which now comes to their own court to say, carve out that independence in terms of funding for the judiciary, and then they will have the right to be the ones to adjudicate over it?
You see, you cannot be a judge in your own case.
So where would you take the matter?
You see, I'm sure the way and manner things are going today, Lord Denning, may God bless his soul, will be turning his grave because of some of the fundamental flaws that are embedded in the current judiciary. As you've stated, can you go and bring a matter that involves me to my court? What judgment do you want me to give?
So whose court would you take it?
No.
If you have to go to court and say, look, the judiciary should be funded directly, and you go to court, who will adjudicate?
There should be executive order. You carry a bill or this to the National Assembly, the National Assembly should make pronouncement, and the President could assign his signature to it without going there. Two, I want to believe that Justice Kekere is really, set for this job. What she should do is to make sure that all these ex parte motions, frivolous, you see a judge on Friday or Saturday, midnight, you will just grant ex parte motion. For God's sake, why do you find this? When this day has closed, the day of the working day has closed, you find ex parte motions being sent to the press around 12 midnight. He should make sure that some of these judges should be looked at straight into their eyes and tell them that, look, they should stop these ex parte motions. Three, let us overhaul even the law school. Just like in Britain, with your first degree, you don't go to law school. You must have a master's degree to improve the quality and quantity in terms of level of thinking, and also in terms of, if you look at the English, well, I'm sorry, with due respect, some of the people that I meet and they tell me they are lawyers, I don't believe. Because if I look at the text of English, I tend to wonder. Because I read English in my first degree. So, there's the need to upgrade, to conform with the beautiful standard of people like the Lana Silk. They've gone through the rudiments of law, and they've been able to pop up to that highest peak of the legal profession. Look at sound English. Look at level of perception that is given. But there are some of these young ones that don't know. Three, I strongly believe that Justice Kekere should make sure that in terms of appointments, as rightly stated, let people that are tested and trusted, let people that know the law, let people that have served either on the bar or at the bench with sound philosophical thinking and legal backing to be brought in as judges. Do not bring in people based on political considerations, because I've seen some governors, because they want to go and impose their political empire, they take their daughters, they take their wives to either High Court, Court of Appeal, and they're giving judgment. I mean, they're giving position as judges. It's unfortunate, it's unfair. In those days, you don't think like this. They'll bring you from nowhere when you don't know anybody and make you a judge. So there should be that thinking where meritocracy comes over a kind of mediocrity.
All right, thank you very much, Dr. Modibo. Now, like my learned Silk here to tell me what you think the CJN, or rather tell Nigerians what you think the CJN can do as regards quackery. Dr. Modibo had mentioned that even those who are qualified, you know, I mean, there are issues and what the law school should be like. And away from those who have even gone to law school, we know that there's so many people parading themselves as lawyers everywhere. Some even go to court, and I mean, all kinds of things happening. So how can the CJN deal with quackery? And then the issue of nepotism. Dr. Modibo did mention that, of course, we know in this country there was a particular CJN who, you know, appointed his son as a judge in the Federal High Court, his daughter-in-law as a High Court judge. And then in the Federal Capital Territory, his brother became an Auditor General of the NJC. So how can the issue of nepotism, which some say is really very huge in the judiciary, be dealt with by the CJN?
Yeah, okay, thank you very kindly. Regarding appointment of judicial officers, the Constitution is very clear on the qualification of an appointment. For you to be a judge of the High Court, you must have practiced law for a period of 10 years. The question is there anybody that was appointed that did not meet the constitutional criteria? If there's anybody you know that did not meet that constitutional criteria, let us know.
Perhaps moral criteria.
I'm coming. I'm taking the questions one by one. We'll start with the Constitution is a ground norm. The Section 1, subsection 3 says that every other law flows from this Constitution. And then the Constitution, it says the Constitution is everything. Okay, every law flows from it. Every norm flows from it. Every practice flows from it. And any law or practice or norm that is inconsistent with the Constitution is, to the extent of its inconsistency, void. So is there anyone in that list that did not meet the constitutional criteria? That's number one. Then you have to balance these things. While I would not support or say that somebody will start appointing all his relations, but at the same time, if a relation is qualified, should you disqualify that person because he's related to someone? These are some of the issues, okay? You are here in the studio doing your work, working very hard, very fervently, and by the grace of God, in the next 20 years, your husband becomes the minister for information in Nigeria, and you become you need to become the NTA Director General. And they say, oh no, because the husband is the Minister of Information, remove her. Apply injustice. Whereas the preamble of the Constitution says we're a nation founded by Constitution, by justice. And he said, under God. Our Constitution in its preamble recognizes the fact that Nigeria is a nation under God. And so whatever we do as a public official, as an individual in the private sector, or wherever we are, is it such that you, giving account to God, you can say in your heart of hearts that this is pure, this is clean? Read the preamble of the Constitution. Our Constitution also says a nation that is founded on unity, one united, indissoluble entity, founded on the principles of freedom and justice. Would you say that what we have done accords with justice is a matter of the heart? It's a matter of conscience. And like one of our founding fathers say, conscience is an open wound. Only truth can heal it. Danfodio said. So these are the things. The Constitution has taken care of everything. So whatever we do, can we say that it's such that giving account to God is just? Can we also say that giving account to our Constitution that talks about equality in Section 36 of our Constitution, that talks about justice, is it also just? So if it's not, then we shouldn't do it.
All right. Now, we are running out of time. We don't have time anymore.
Could you just round off? Could you just round off in 30 seconds?
Right. I also wanted to mention there is a need for his lordship She is already the head of the National Judicial Institute, recognized by the NJI Act for training of judges, but more needs to be done. That institute needs to be equipped financially. If that institute is equipped financially, they will conduct continuous training to ensure that the honorable judges' training accord with international and national developments.
All right.
They should not just be left in the court working from day and night
without
the kind of training, not a 1 year conference of all judges every year. No, equipping that institute with a kind of modern technological and other kinds of training.
Continue to train
the judges. So it becomes a natural thing.
Thank you very much, Lanet Sek. Dr. Modibo, just in 30 seconds, please.
Thank you very much.
Thoughts.
What is considered as morality comes into play. Morality. That is one of the ethics and etiquette of the whole grand norms of the judiciary and even the worldwide. If you have morals, is it justifiable for you to appoint your own children, your child, your wife, at the same time, because you are head of an organization? It's not fair. It's not fair. That means it has become an inheritance culture.
No, we understand that now.
A poor man
while they may not have run foul of any law, you are just talking about the morality of it. Well, let's thank you very much at this point, Dr. Ibrahim Modibo, development communication scholar and public affairs analyst. I'd like to thank you very much for your time and thoughts on the program. Thank you. Yeah.
And then Lanet Silk, James Igwe, SAN and a legal practitioner, thank you very much for your time. Thank you very much for your contributions.
Thank you very much. I wish our nation rule of law.
Indeed.
In all ramifications.
Indeed.
All right, so that's Good Morning Nigeria this Friday. Thank you so much for watching. Have a great weekend. I'm Ian Ray John.
And I'm Victor Azu. Join us again on Monday.